Hi guys, and welcome back to Contract B, and this is part 3 of the week 4 videos. This particular video is on undue influence. So here we are back at our Prezi presentation, and we'll have a little look at undue influence. Now here, much like duress, we also have a situation of a dominant party and a weaker party, so there's a common thread there. However, instead of the kind of threats that tend to be made in a duress type situation, we're looking more at conduct that might be said to be improper influence. So it might not be as extreme conduct as you sometimes get in duress. However, equity still would class that conduct as undue, improper, unconscientious, for example. Now, we have a couple of categories of undue influence: actual and relationship-based. And there's fairly significant differences between the two. If we look at actual undue influence, it has a lot of similarities with duress. Like I said, the conduct might not necessarily be quite as out there as you get sometimes in the duress type situation. Nevertheless, equity does step in because the influence is undue. So we have here one party having the capacity to influence. It was exerted, it was undue, and it caused entry into the contract. Now, just to underscore the similarities between duress, the common law vitiating factor of duress, and equitable relief for undue influence, both were mentioned in that rather amazing case of Barton and Armstrong, where the murder threat was made. Now, the court there said that they would either step in for the common law vitiating factor of duress or because of the equitable notion of undue influence. So you can see why the text said, is there really any room left for duress when you have this equitable notion of undue influence? The number of cases of duress have dropped away. But as I said in the earlier video, at this point in time, for the purpose of this unit, we certainly have a common law vitiating factor of duress and an equitable notion of undue influence. So that's Barton and Armstrong. Just a bit of similarities there between what we covered in duress and undue influence. The main case that you'll look at in the casebook is Khan and Khan. And in this particular case, you had a dispute between members of a Muslim community. What had happened was Mrs. Sadiq, who owned a property, said that she would rent that property to a husband and wife before they had negotiated the terms and conditions of the sale of the property to that husband and wife. Now, Mrs. Sadiq kind of thought that she was doing this husband and wife a bit of a favour by letting them rent the place before they'd even agreed on the sale terms. And she thought it was a bit rich that they started to dispute who was going to be responsible for paying the property and the water rates. And after all of this, it left a bit of a bad taste in Mrs. Sadiq's mouth, and she didn't necessarily want to go through with the sale if these people were going to be like that, just in relation to renting. So the mother was cooling off the sale, and the son, the mother's son, kind of thought, oh dear, we can't back out now because we are honour bound to go forward with this sale agreement. So the parties called in the local mufti, who is obviously the Muslim leader who would be able to advise the parties on their obligations in this situation. Now, I guess you're kind of thinking here, hang on a minute, if the mufti is the one that's going to be telling everybody what to do, the mufti is the one that's going to have the influence here, he's not a party to this sale contract, and you're absolutely right. However, equity is not so narrow-minded as to chop off from consideration what might actually be an improper influence that shrouded that particular transaction. And so where you've got one party, the weaker party, being subject to influence by a third party, and you have the dominant party to the contract taking advantage of that influence in that kind of improper situation, then equity is going to step in, even though the person providing the influence wasn't a party to the contract. So that is the third party issue in Khan and Khan. Was there actual undue influence? Well, this is what the Mufti said. Everybody was required to complete this contract at $490,000 because of this Muslim precept of my word is my bond. That is, if I say I'm going to complete this contract with you, I actually will. Now, this was a religious instruction. Mrs. Siddique knew this was a religious instruction. This is what she should spiritually be inclined to do, although she wasn't legally obliged to do it. Mrs. Siddique really didn't want to go ahead with this sale, and she thought, well, what's the best way forward here? How can I look like I'm complying with the Mufti's direction but still try and get out of this transaction? So she came back with a counter offer of $510,000 because she thought, the purchasers just wouldn't be able to afford it and she'd be able to get out of the deal. There were further negotiations that went on, and the Mufti said to Mrs. Siddique, you have to take $495,000 because this is all the husband and wife can afford. Your word is your bond. You have to go ahead with it at that price. If you do so, you're going to be rewarded in the afterlife. So there's a little bit of a carrot, spiritual carrot, for Mrs. Siddique. However, then the tone of the conversation got a bit darker, and the Mufti actually said to Mrs. Siddique, lucky you're not in any other country. If you had been in a Muslim country, it would be a bit different. Now, Mrs. Siddique gave evidence that at that point she got a little bit scared because the inference was that she would certainly be in trouble. I don't know whether that meant physically, spiritually or whatever. But if she didn't perform the oral agreement, that would be a pretty bad thing. Now, was all of that undue influence? The husband and wife sought to say, well, Mrs. Siddique actually knew that she legally wasn't obliged to sell this particular property and that all the Mufti was doing was giving her some spiritual advice. She owned a number of residential properties. She was a smart woman. She wasn't going to bend to this transaction just because some Mufti had told her it was the right thing to do. However, the court stepped back and said, hang on a minute, look at all of the situation here. Look at all of the circumstances. You've got spiritual advice and Mrs. Siddique gave evidence that she thought the Mufti was closer to God and could affect her prospects in the afterlife. Shrouding all of these discussions here, like an overlay on the discussions that were going on. And that really was the hallmark of undue influence. The husband and the wife obviously approved of the Mufti's rulings. They got Mrs. Siddique to sign a contract on the spot, but the husband knew that just getting her to sign off on the contract wouldn't guarantee in an ironclad fashion that she couldn't back out of the deal, because there would have to be, an exchange of contracts at the solicitors and various other formalities. And so the husband got Mrs. Siddique to sign off on a memorandum that effectively would have prevented her from backing out of the deal. Obviously, the husband and wife were present when the Mufti advised Mrs. Siddique of her duty, and in all those circumstances, they couldn't show that they didn't take advantage of Mrs. Siddique's obedience to the Mufti, so they couldn't enforce that particular bargain. Fairly common sense result, I think, in this particular case. And the court goes on to say, really, equity does have to be very protective in circumstances of spiritual advice, because people can be so easily swayed in the real world, by thinking of the ramifications that might be said to occur in the afterlife, depending on the decisions they make now. So that's Khan and Khan. Interestingly, the court notes that the plaintiff could have presented her case as a Category 2A undue influence, where the relationship is presumed to involve undue influence because the relationship of spiritual advisor and devotee is one of the recognised relationships for 2A. So without further ado, let's have a quick look at the Category 2A kind of undue influence. Category 2A is probably the easiest kind of case for a plaintiff to mount because they get the benefit of a couple of presumptions. Firstly, once they show that the relationship falls within this list of recognised relationships of influence, then the plaintiff doesn't actually have to go ahead and prove that there was actually a relationship of trust and confidence inherent in that relationship. Okay, so it saves them a little bit of work there. Once we have this irrebuttable legal presumption that the relationship involved influence, all you really need to do is show that there was some kind of questionable transaction, and equity basically does the rest for you. It assumes that the influence was undue, and then the onus shifts. I'll talk a bit more about the presumptions in a minute. In terms of Category 2B relationships, if your relationship does not fall within one of those recognised relationships for Category 2A, then you have to do a little bit more work as the plaintiff. You have to show that one party actually had this position of ascendancy or influence and the other party was in a position of trust or dependence. So you have to lead evidence to show that there was a relationship there and that it involved trust and confidence. Essentially what the court is looking for are the kinds of hallmarks that are apparent in a fiduciary relationship. That is a very sacred relationship between one party and the other, where the trusted party is only capable of acting for the benefit of the trusting party. If they try and act for their own benefit, then the court is going to see that as improper. The main case that you'll look at here is Johnson and Buttress, and here we have a 67-year-old man, low intelligence, little capacity for experience in business, reliant on others. His wife dies, and then her blood relation takes over in looking after the donor in this particular case. He thinks that she's been very kind to him and transfers the land on which his house stood. After he died, then his estate, not surprisingly, sought to have that transaction set aside for undue influence. Now, you can see here that the relationship between the man and his wife's relation was not one of the Category 2A recognised relationships. So the estate didn't get the benefit of the presumption that this was a relation of trust and confidence, so that had to be proved. And the court said, wherever the relation between donor and donee is such that the latter is in a position to exercise dominion over the former by reason of trust and confidence reposed in the latter, the presumption of undue influence is raised. So, plaintiffs, don't despair. Just because you don't fall into a Category 2A relationship, if you can actually lead evidence to show a relationship of trust and confidence, you're going to get over the line. Once you've got over that line, then the presumption of undue influence is raised and the onus shifts to the defendant to prove that whatever transaction occurred was the pure, voluntary, well understood act of the mind of the weaker party. So in this particular case, there was various different indicia that the donor, Mr. Buttress, was in a relationship of trust and confidence with this blood relation of his ex-wife. He was illiterate, ignorant of affairs. He had a kind of strange disposition of matter, age and capacity. The improvident unfair nature of the transaction. He didn't get any independent advice, and there was some other things floating around in the factual matrix as well. So there was a relation of trust and confidence that was proved. The onus shifted to Mrs. Johnson, and she couldn't show that Mr. Buttress gave her that gift as a full and free exercise of his voluntary will. So the transaction was set aside. So let's go and have a little look at presumptions. The text does go on about this. I'm not sure that it's terribly clear, so I'll quickly run through it here. You've got two presumptions that you need to consider when you're talking about undue influence. The first one is an irrebuttable presumption of law. Okay, and this is the one that we were talking about with category 2A. Undue influence. Once you can prove that you have a relationship that falls within the category 2A relationships, then you will have the benefit of an irrebuttable presumption of law. That is, that relationship will involve influence by one party over another party, and that just makes sense because of the nature of that particular relationship, like parent and child. Okay, so if you prove fact A, that is, you have a relationship that's within the 2A category, then presume fact B is assumed by the courts. So that is the relationship of influence. The second presumption that you need to consider is the rebuttable presumption of fact, and the text sometimes calls this an evidentiary presumption. Really, this is just a common sense inference, and it arises where one fact A is proved. And here in category 2B, if you can prove a relationship of trust and confidence, then presumed fact B is prima facie assumed, and that is that you have this relationship of trust and confidence. Presumed fact B is that, in fact, the influence that was exerted in that relationship was undue. Okay, you can lead evidence to rebut this, and obviously if you can show that the party acted freely and voluntarily, then your evidence may rebut that presumption. So for category 2A, you're going to be looking at, I guess, the plaintiff's easiest evidentiary burden here, because they get both of those presumptions in their favour. All you have to do is show that you have a relationship that falls within category 2A, then you get the benefit of that irrebuttable presumption of law that it was a relationship of influence. Once you have that relationship of influence being presumed by the court, then the court says, well, we're going to raise a rebuttable presumption of fact, or evidentiary presumption, that the influence was undue. So for category 2A, quite nicely for the plaintiff, you just have to prove a relationship that falls into category 2A and that there is a questionable transaction. The court will then presume undue influence. The onus shifts to the defendant. For category 2B, you don't get that irrebuttable presumption of law happening here. So you have to show a relationship of influence, that is trust and confidence and so forth, and a transaction that's questionable. Once you've done that, then you get the benefit of the last presumption, which is that rebuttable presumption of fact, or as the text says, evidentiary presumption, that the defendant abused the influence, that is, that the influence was undue. Then, again, the onus shifts to the defendant. In category 1, now this is the non-relationship based undue influence, we have no benefit of presumptions. So you have to go ahead and pretty much prove everything. Okay, so the plaintiff has to show that the party had a capacity to influence, it was exercised, it was undue, it brought about the transaction, and then the onus will shift to the defendant. Now, if you have a little look at the Royal Bank of Scotland and Ettridge case, which is the case the textbook briefly mentions, you will find some rather interesting and I think fairly explanatory snippets from that case to assist your understanding of the various presumptions. I won't bother going through them all here. I've placed a 1 and a bit page extract from that decision up on the Moodle for you, so you can explore that at your leisure. But I do think that if you had a little read through that, 1-ish page extract, the presumptions will make a lot more sense to you. So that is The Wonderful World of Undue Influence, and I'll leave it here for this video. The last video, part 4, will cover unconscionable conduct. So I'll see you then. Thanks, guys. Bye.